Hello, everyone, and welcome to Uncivil Law. And we are here with an update in the George Floyd murder, the one that has been a major instigation for much of the violence that has been occurring recently, in large part. The knee on the neck, the 8 minutes that was particularly shocking to much of America for both, conservatives and liberals and left and right. It was a disturbing incident in many cases because it just felt so over the top. Now, whether or not that's criminal or not, of course, is a whole nother set of questions and are legal questions that we have to arise to, and are questions that we're going to try to address at least in part, because the person with the knee on the neck, Chauvin, the officer who had the knee on the neck, his third-degree murder charge has been dismissed by the judge. The second-degree murder charge remains pending. All the charges with the other three officers also remain pending, so he's still on the hook for potential crimes. But we're going to cover what we know so far and what we don't know and try to figure out what the legal standards are that emerge from this. And there is one point I'd like to just start with, because this does seem to be a point of confusion for a lot of people on the George Floyd murders with respect to the fentanyl and whether or not George Floyd was on fentanyl or not. The question isn't whether or not he was on fentanyl. The question isn't even, but for the fentanyl, would he have died? That's not the right question. The question here is, but for what the police did, would he have died? So if what the police did would not kill an ordinary person, premise. If it would not kill an ordinary person, premise, but it did kill Floyd because Floyd was on fentanyl, that's irrelevant. You take the victim as you find them. It's eggshell skull doctrine. If what you do causes an injury and it causes more injury to the person you do it to than it would to a normal person because of some weakness they have, whether that weakness is inherent or even if that weakness is self-inflicted, it doesn't matter. It doesn't matter. You take the victim as you find them. So the question isn't, well, if he hadn't been on fentanyl, would he have died? Doesn't matter. The only question is, did what the police do cause his death? Was what the police did a but-for cause? So it would be correct to say, if he was going to die at that moment, regardless of what the police did, if he was going to die because of the fentanyl, regardless of what the police did, then that would be relevant, because then the police aren't a but-for cause. If the fentanyl is what actually directly killed him, then yes, the police would be not guilty because what they did didn't have a causal relationship to what occurred. It wasn't causal. But if what the police did exasperated that death by even 1 minute, by even 1 second, if it happened 1 second sooner because of what the police did, then it would have otherwise occurred, the police are guilty of murder. That's just easy peasy criminal law. It's really, really simple on this one. If you cause someone's death 1 second earlier than it would have happened anyway, that 1 second was theirs, not yours, and you're guilty of murder. If you rob someone of 1 second of life or you rob them of 50 years of life, it's murder. Assuming all the other factors are there. So this whole thing about fentanyl, whether he was on fentanyl, is a bit legally irrelevant unless you can show that what the police did was non-causal. It didn't exasperate it. So I just wanted to begin right there because that seems to be a big point of confusion with a lot of people. Was George Floyd on fentanyl or not? I don't care, and it's probably not relevant anyway. But all that being said, let's turn to what this police officer did or did not do and his potential liability here. And we're going to cover the principal guy, the knee on the neck guy. We're going to cover his liability today and what he did or did not do. So we're going to cover both the second-degree murder charge and also the third-degree murder charges. We'll skip the manslaughter stuff for now in the interest of time. We'll just do the major murder charges because, obviously that's the most interesting. So we'll skip the manslaughter stuff if it comes up, and we'll just deal with the murder charges for now. So here is what the operative issue is. Okay. Under the Minnesota law, a person is guilty of second-degree unintentional murder, which is possible in this state, if he causes the death of a human being without intent. It's right in the statute, without intent, to affect the death of any person. So if you cause death without the intent, or another way to say that is without the purpose, it wasn't what you were trying to do. You weren't trying to cause a death. You did cause a death while committing or attempting to commit a felony offense other than criminal sexual conduct in the first or second degree with force or violence or a drive-by shooting. So this is what's known as felony murder, essentially. You were committing some underlying felony inherently dangerous, and in the course of that felony, you caused someone's death. Even if you weren't trying to cause it, you're responsible. And there's a whole bunch of scenarios where this would pop up in the United States, but I'll give you some like really common ones that would pop up. So the most common scenario where this would pop up, and by no means the only one that would pop up, but the most common scenario that this would probably pop up would be something like an ongoing robbery. A bank robbery or a robbery of a convenience store would probably be the one where most would pop up. And so, the gang goes in to rob the liquor store, goes in to rob the convenience store, goes in to rob the bank, whatever, right? And maybe they have guns on them and maybe not. Doesn't really matter. And, as part of that robbery, the clerk shoots one of the people, or a police officer shoots one of the people, or even one of the criminals shoots one of the other criminals, whatever. And the question, and that means that's felony murder. You created an inherently dangerous situation. And the fact the clerk shot you means you're guilty of murder because you're the one with the underlying felony. So yeah, the clerk shoots one of your fellow robbers, and now you're on the hook for murder. And you're like, wait, what? Yeah, you created an inherently dangerous situation. The clerk is the one that shot your fellow compatriot. So whether or not the clerk is guilty of something, I don't know. We'll deal with that another problem. But whether or not the clerk is guilty of something has really nothing to do with your legal liability. So the fact that your co-person was shot by the clerk, or shot by a person who was concealed carry, or shot by a police officer really doesn't matter. That's felony murder. So that's basically what's going on. Now, there is an interesting twist here in this specific law, because in most states, and I know the judge is going to get to this, and that's where it's going to be educational for everybody. In most cases, I apologize. In most states, you can't use the death as the underlying felony. So you can't use the death as the underlying felony. So you can't use, you can't say, well, the person died and that's a felony, and because the person died in the course of that felony, it's second degree murder. So you can't use the death as the underlying felony. You need something independent from it other than the death. And the problem here in the George Floyd case that I spotted, and their court is going to get to, I'm sure, is the underlying felony that they've been trying to use is the assault, right? The knee on the neck is a criminal assault, to be sure. It's a felony assault. And they're saying, well, that felony assault resulted in the person's death. In many states, that wouldn't fly. You can't use the underlying death as the predicate felony in many states. So maybe you can in Minnesota, but that always was a little bit weird. You're using the underlying criminal assault as the predicate felony for the felony murder. Doesn't really make sense in many states. So we're going to figure out if it makes sense in Minnesota, I guess, real fast. All right. So you must, and then of course, by the terms of the own statute, it also does exclude criminal sexual conduct or drive-by shootings. Okay. To prove that Chauvin, the guy with the knee on the neck, is guilty of this unintentional second-degree murder, otherwise known as felony murder, the state must prove the following elements. Floyd died. That Chauvin caused Floyd's death, where caused means that Chauvin's conduct was a substantial causal factor. It was causal, in fact. There is a proximate cause element basically here. If you're trying to figure out what substantial here means, although it's not really using this language, it's hinting at proximate cause. Normally that's language we use in civil law, but that's what's hinting at as a substantial factor. It's something, there could be things that are too attenuated somewhere down the line. That's what substantial here probably means. And that Chauvin at the time of causing death was committing or attempting to commit another felony offense, and that's where I thought this is going to get a little bit tricky, is the other felony offense. What is the other felony offense? the felonious assault. I'm like, that doesn't seem to really work, or it wouldn't work in many states, but it's going to work here. Okay. With respect to this third element, the underlying felony offense the state relies on in charging Chauvin with the unintentional second-degree murder is the third-degree assault. Right. Normally that wouldn't fly in a lot of places. You can't use the underlying assault in the felony murder. That doesn't normally make sense. Chauvin is guilty of third-degree assault if he assaults another and inflicts substantial bodily harm. You know what assault meant without me telling you, but yeah, that's what it means. You assault someone and you cause harm. That's assault. Yeah, deep thoughts. To prove that they're guilty of third-degree assault, the underlying felony that you still have to prove. So you still have to prove the underlying felony. You can't convict a felony murder without convicting also of the underlying felony. So that means the jury can't reach a guilty verdict in the third-degree murder unless they also find guilt of the underlying felony, in this case, the assault. So they also have to find implicitly that Chauvin assaulted Floyd, defined as either intentional infliction of or the attempt to inflict bodily harm upon a victim, or an act done with intent to cause Floyd to feel bodily harm or death. So we got some ideas here that they had to have this intentional infliction or the attempt to inflict bodily harm. So attempt here is just criminal. It just means in the same sense of attempted murder. So it's like attempted assault, right? So you were intending to do it. It was your purpose to inflict this harm. And obviously a lot of what the police does can be thought of as infliction of. So they're whether or not his intent is there is a problem, potentially. And so you have to find both these things. Chauvin inflicted substantial bodily harm on Floyd, where substantial bodily harm is defined as bodily harm that involves a temporary but substantial disfigurement, causes a temporary but substantial loss of impairment of a function of any bodily member or organ, or causes a fracture of any bodily member. So it has to result in some sort of notable, if temporary damage. All right, put all together. So now we're going to put it all together because we have to prove a whole bunch of things. So to prove all together, the state will have to show Floyd died, that Chauvin's conduct was a substantial causal factor. Basically, it's not so attenuated as it doesn't count, which seems impossible here. It's definitely not attenuated in that way. It would be substantial in this context. That Chauvin intentionally inflicted or attempted to inflict harm on Floyd, or intended to cause Floyd to fear immediately bodily harm or death, and that Chauvin inflicted substantial bodily harm on Floyd. So element 3 seems potentially the weakest point of this analysis. If I were the defense, that would be where I would be focusing on as point number 3, his intent. That would be my first thought, at least. Viewed in the light most favorable to the state, which is where we are because we're on a preliminary motion, guys, right? So we're going to view this in light of the party. We're going to view this we're going to view this in light against the party moving for the action. So the party asking for dismissal is the defense. So we're going to view it in the light most favorable to the prosecution, because that is what we do in criminal law land, or just in law land, period. Especially at this point, because we're on a probable cause standard. So yeah, we're gonna view this. We're gonna view everything that is available in the light most favorable. What will actually be proven at trial is a whole nother set of problems. But we're going to view it in the light most charitable to the state. That's fine at this point. The evidence here would lead a person of ordinary care and prudence to hold an honest and strong suspicion that Chauvin committed second-degree unintentional murder. Fair. On the record before this court, for probable cause purposes, there is no issue as to the first and fourth elements. Yeah, Floyd died. Yeah, everyone agrees on that. Any substantial bodily harm, which is kind of implicit in the death. Yeah. For the purpose of probable cause challenges, the issue is where the state has alleged warranting proceeding to trial on elements of whether Chauvin's conduct was a substantial causal factor in Floyd's death, and whether Chauvin intentionally or attempted to inflict bodily harm on Floyd, or intended to cause Floyd to fear immediate bodily harm or death. In the court's view, the answer to both these issues is yes, on a probable cause standard. Probable cause is a very low standard. So on this point, yeah. All right. The state has alleged sufficient evidence that Chauvin's actions were a substantial causal factor. A defendant's actions are a substantial factor so long as they contributed to the death. The state is not obliged to prove the specific mechanism of death. They don't have to prove specifically how it occurred, just that it caused it. Nor is the state required to prove his acts were the sole cause of death. Yeah, that would be all you fentanyl people. Or like, he was on fentanyl. No, that is definitely not relevant. They don't have to prove it's the sole cause of death. Definitely not. No. Rather, the state need only prove Chauvin's action were a contributory cause to satisfy the substantial causal factor. Here, Chauvin pressed his knee into Floyd's neck while Floyd was lying prone and face down on the street, effectively pinning Floyd's neck and face into unforgiving concrete of Chicago Avenue for more than 9 minutes and 40 seconds. Based on the videos from the officers, the state can be expected to argue that Chauvin maintained that forcible presence on neck for more than 4 minutes and 40 seconds after he uttered his final words, for almost 4 minutes after Lane first raised the possibility that Floyd had passed out, and inquired if we should roll him on the side, for more than 3 minutes and 25 seconds after it appeared that Floyd may have drawn his last breath, and for more than 2 minutes and 40 seconds after Krung reported not detecting a pulse. After conducting an autopsy, the medical examiner concluded Floyd's death resulted from cardiopulmonary arrest, a heart attack, complicating law enforcement subdual restraint and neck compression because of the knee on the neck. There's a lot of words to say he had a heart attack because of the knee on the neck. And ruled the manner of death was homicide, which, in your options, it is homicide. Your only other options are like accident, suicide. What else is there? Yeah, and then like other. So yeah, there's not a lot of categories. The United States Armed Forces medical examiner was asked to consult on and upon independent review issued a report stating his agreement with the autopsy and cause of death certification, concluding the death was caused by the police subdual and restraint, the knee on the neck, and the subdual and restraint had elements of positional and mechanical asphyxiation. Because of the way that was done, it caused him to stop breathing. In other words, the state had presented evidence that by restraining Floyd in a prone position on the street and pressing his knee into the neck, Chauvin effectively immobilized Floyd in a position that caused him to stop breathing, leading to his death. Viewed in the light most favorable of the state, these facts are more than sufficient to present the fact question on the causation. That's completely true. There is more than enough here to suggest it is causal. Now, whether or not it is causal, of course, is a whole other set of problems, and that's for a jury to decide. There's enough at least to provide the suggestion for probable cause. Yeah, no problem with any of that. During the first 4 minutes and 40 seconds while Chauvin pressed his knee on Floyd's neck, forcing his face into the concrete, Floyd called out, "I can't breathe," a couple dozen times and desperately pleaded he was dying. Yet the video recordings indicates that Chauvin never relented and never lessened the pressure on the neck against Floyd's neck, even while he pleaded, "I can't breathe, please your knee in my neck." Chauvin, in a tone the state characterizes as dismissive and taunting, responded to Floyd's cry for relief by telling Floyd it takes a heck of a lot of oxygen to say those things. Yeah, that is a bit of a problem with the police. They don't really understand, and this is also just a linguistic problem, but there is this idea that, like, if you can say "I can't breathe," it must mean you can breathe because you're using the words to say it. But to say "I can't breathe" means basically I'm having trouble getting oxygen in, right? Not necessarily oxygen out. So I can't breathe properly. As a person who had childhood asthma, I appreciate the difference between these twin statements, because, whether or not I can say I'm having trouble breathing is like, yeah, you're breathing just fine. You're saying, I'm like, no, not really. So I appreciate this difference as a person who grew up with asthma. Those facts alone raise at a minimum a fact question for the jury regarding the intent and whether Chauvin intended to inflict harm, intended to cause Floyd or bodily harm or death, which is perfectly fair, right? It raises a fact question. There's enough to suggest it. It's a question of fact. Leave it to a jury. In any event, where Chauvin's actual intent during the early stages of the subduing of Floyd lying prone on the streets, the inferences to be drawn in the state's favor. Let's see. The inferences are to be drawn in the state's favor at this point as to the intent for the progress suffice for probable cause purposes. Why is Streamlabs not pressing on? All right. Interesting. Maybe I made a mistake. Anyways, where were we? I'll have to put the super chat back on thing. Suggestion: pop shield. Plosives are hitting the mic. I do have a pop shield, or I have a foam shield for that. So yeah, I don't like the pop shield. I found it so visually distracting. But I do have this foam thing on the mic to try to pick up some of the plosives. But thank you. During the first 5.5 minutes after arrival, Chauvin was dealing with Floyd as he was talking incessantly and constantly moving. Over the next minute, the vigor of Floyd's physical movement of his shoulder and head declined, as did the frequency and volume of his speech. His speech was deteriorating gradually, with words turning to mumbles and then mumbles to grunts. As Floyd was manifesting signs of losing consciousness, Lane asked Chauvin and Covin if they should roll on his side into a recovery position. Chauvin said no. Rather than moving Floyd out of the inherently dangerous position, Chauvin told King and Lane to stay put where he got him. Less than 10 seconds later, Floyd uttered what proved to be his final words, "I can't breathe." Less than a minute later, Chauvin heard Lane remark that Floyd was passing out. It appears from the officer's video that Floyd may have stopped breathing at around 8 minutes and 25 seconds. Shortly, or is that 8:25 in the morning? I'm not sure. I think it's 8:25 on the video time. 8:25 on video time. Shortly after that, in response to an increasing chorus of pleas from bystanders to check his pulse, based on observation that Floyd was no longer moving or resisting, and didn't appear to be breathing, Chung clicked his wrist for pulse, telling Chauvin and Lane, "I can't find one." Chauvin responded, "Huh," to which Kong clarified he was checking for a pulse. After a second brief check for a pulse, Kong repeated, "I can't find one." Not super promising. Seems a little wanton and depraved to me. Yeah, seems a little wanton and depraved to me. Notwithstanding, Floyd has gone silent and motionless, the mounting evidence of his loss of consciousness, the plaintive cries and demands from bystanders, and the obvious reality that Floyd was no longer resisting and was no longer non-compliant, which would indicate there's no longer a need for force. Chauvin's demeanor never changed, and he continued kneeling on Floyd's neck, applying constant pressure to Floyd's face to pavement for an additional 2.5 minutes. When the EMTs arrived to provide Floyd medical aid, Chauvin heard Lane tell them what Chauvin certainly already knew, notwithstanding his continued kneeling, that he was non-responsive. Right. Even so, Chauvin continued to kneel on Floyd's neck for another minute, even when the EMTs arrived. That's nice. Maintaining pressure on the neck, even while emergency personnel attempted to check his neck for a pulse. That's super promising there. Because the court must draw all favorable inferences from the evidence in favor of the state for the purposes of this probable cause challenge, and that's perfectly proper at this stage of proceedings. Don't panic, guys. He gets presumption of innocence, and he has to be proved beyond reasonable doubt at trial. We're on a very preliminary stage here. Don't panic. This is perfectly normal. Chauvin conducted these final 4 minutes and 40 seconds as strong evidence of his intent to inflict harm. Fair. That's a fair conclusion for the purposes of our present endeavor, yes. That conclusion is further supported by the comments. Bystanders scream at Chauvin and others that defendant Floyd was not resisting the arrest, that Chauvin was responsible for stopping breathing, that Floyd was not moving, and that he was dying. Chauvin occasionally looked directly at the crowd as they pleaded with him to remove the knee from the neck and informed him in real time of the consequences. And he had that really sort of defiant look on him too, like, I'm in charge and I'm not going to do it specifically because you're asking me. I don't know, that's kind of the look in his eyes, it seemed to me. It's like, I'm in control, I'm the boss, you can't tell me what to do. It's like, yeah, no, that's not great. Rather than removing the knee from the neck, however, Chauvin rolled his knee back and forth on the neck, maintaining pressure on the respiratory system, which the state contends led to him not being able to breathe anymore, which seems probably pretty plausible. That too, given the inferences must be drawn in the state for our present purposes to dismiss for lack of probable cause, is strong evidence of the intent. I cannot disagree. Chauvin's training also reinforces, given the inferences the court must draw in the state's favor, that he intended to inflict his bodily harm. The policy authorizes only the amount of force that is objectively reasonable in light of facts and circumstances known at the time of force is used. What would a reasonable person do in these circumstances? Consistent with that policy, officers are trained to place a restrained subject on their side in order to reduce pressure on their chest and facilitate breathing. Officers are told a neck restraint is not permissible on a subject who is passive or is not resisting. Moreover, they are told to check the subject's airway and breathing and to cease a restraint and start CPR if they stop breathing. Chauvin had been trained in these policies. Chauvin was a 19-year veteran. Chauvin had received numerous trainings during his time on regarding the proper use of force, but even after Lane implicitly reminded him of these policies by asking him if they should roll him over on the side into recovery position in accordance with the training, Chauvin persisted in acting in disregard of his training by continuing to kneel on the neck even after Floyd had stopped talking, had become totally unresponsive, had appeared to stop breathing, and no longer had a pulse. Yeah, whether or not this is a proper procedure in some, this is also a bit of a point in confusion, it seems to me, in the George Floyd of discussions. Whether or not this procedure is appropriate in some circumstances doesn't say whether it was appropriate in these particular circumstances, right? So even assuming that a knee on a neck is an appropriate procedure at some points, which is, we can take that as a given. Sure, why not? It's part of the many tools a police officer might have to restrain someone. A knee on a neck might be a valid thing to do, potentially. That seems arguable. But whether or not it was valid in this particular situation, particularly given what this particular police officer knew at the time, and knew for a fact, not only based on his own observations, because he was there, but based on what his fellow police officers were telling him, based on what the crowd was telling him, right? He knew for a fact, and he still persisted, arguably well past whatever the point of a knee on the neck is. So even assuming it is part of a valid police restraint mechanism, there are other considerations in work, like there is many at times in law. There's not like one thing that's always okay every time. You can't just because you can mace someone sometimes doesn't mean you can mace them all the time. Just because you can hit him with a nightstick sometimes doesn't mean you can always do it. Just because you can shoot someone doesn't mean you can always do it, right? There are considerations in play. And again, we're looking at this objectively reasonable, right? So there's a wide range of possible options because we're looking to the reasonable person test, and there's a wide range of reasonable people. So would a reasonable person, any reasonable person, do it at this situation? No, probably not. No, no. So some people seem to be missing this. Oh, it was in the police manual. It's like, yeah, but that really doesn't answer the question. Someone asked, does the judge say the knee on the neck was not valid in this situation? No, because that's not where we are. We're at a probable cause standard. We're not trying to figure out the ultimate question, whether it is necessary or not. We're assuming all facts in favor of the state at this point. So you would assume it was unnecessary, or you at least you would say okay. No, that's not the right way to phrase that. I phrased that incorrectly. You would say, is there enough evidence that a jury could conclude it was unnecessary? That's the right way to phrase it. So the judge isn't saying whether it's unnecessary or not. The judge is asking the question, is there enough evidence that a jury could conclude it was unnecessary? That was the right way to phrase that. And there, I think we're there. Yeah. Chauvin never attempted to place Floyd into a recovery position to check his airway or start CPR as he was trained. Viewing the light most favorable to the state, the evidence more than suffices to present a fact question for the jury's determination of whether Chauvin intended to inflict bodily harm on Floyd to cause fear of harm or death. Fair enough. Chauvin argues that actions did not cause Floyd's death and did not intend to inflict bodily harm. Fair point. Both these arguments miss the mark. They do. They are arguments for a jury's consideration. Right. Here on the motion to dismiss for lack of probable cause, the court is required by law to view all the evidence in favor of the state, right? So here's all the evidence the state has, and to draw all reasonable inferences from that evidence in the state. Is there enough here that the state can make their case? Right? And that's the only question we're trying to do. In any event, as to causation, Chauvin does not even attempt to engage the conclusions of the autopsy report, of those of the independent review of the other medical examiner. This, of course, would be futile, and it would be, because this court must view all the evidence in the light most favorable to the state. So even if there were other medical examiners and other medical reports, that wouldn't matter, because the only question is there enough evidence a jury could believe this particular medical examiner? So it's not even a balancing issue. It's not even like if there were one medical examiner who says, yes, this is what happened, and 9 who said no. That's not the right issue, because the jury could believe the 1 and not believe the 9. Or the other way around. It's up to the jury. That's what they do. Questions of fact, right? So it doesn't matter if there were other medical examiners, because at this point we don't care. That's another issue for another day. Chauvin speculates that fentanyl may have played a role in the death, and he most likely died from opioid overdose. That's okay. Such speculation is legally insufficient for a probable cause challenge. It is. That may be true. That may not be true. But is there enough evidence for the prosecution to move forward? There sure is. A defendant is not criminally liable if a superseding cause intervenes and causes death. If something else superseded it and caused death. An intervening superseding act breaks the chain of causation, right? Because it would no longer be causal, right? Set in operation by a defendant's negligence or other action, thereby insulating the negligence as a direct cause of injury. To qualify as a superseding intervening cause, an occurrence must come between the negligence and the occurrence at issue. That would mean what it means to be superseding. Yeah, it would have to be afterwards, right? It would have to come between the defense action and what ultimately happened. That would make it superseding. Could not have been brought about by the original negligence. That's also one of the things that would make it not superseding, right? Otherwise, it would just be causal. Turn aside the natural sequence of events producing a result which otherwise would not have followed the original negligence. Again, not causal. And not be foreseeable from the original negligence. Another way of saying it's not causal. As a court of appeals observed, a superseding intervening cause of harm is generally the act of a third party, occurring after the defendant's act and operating as an independent force to produce the harm. In other words, a superseding intervening cause is an act committed by another person, in no way caused by a defense action that breaks the chain of causation. Moreover, to qualify as a superseding cause that breaks the causal chain, the intervening conduct must be the sole cause of the death. Yeah, otherwise you're still a but-for cause, even if it was intervening. Yeah, you're still a but-for cause because but for what you did, he still wouldn't have died. So yeah, it would have to be the sole cause at that point to be a superseding intervening cause. Yes, that's what those words mean, yes. Here, Chauvin alleges that Ford ingested fentanyl before Chauvin pinned Floyd to the ground, knelt on the neck and restricted breathing. Chauvin contends only that the alleged drug use was the most likely cause of death, not was the sole cause of death. Right, I discussed this earlier at the top of the stream. If the fentanyl was 99% responsible for the reason he died, the law doesn't care. The law doesn't care. If the fentanyl was 99% of the reason that George Floyd died, it doesn't matter. It doesn't matter. The police only need to be 1% responsible. And they only needed to deprive him of 1 second of life. If we could establish with 100% certainty, the fentanyl would have killed him 1 second later. If we can establish with 100% certainty that fentanyl would have killed George Floyd 1 second later, and the reason he died 1 second earlier was 99% the reason of fentanyl, it's still murder. That's how law works. Yeah, you take the victim as you find him. He was going to die later. Who cares? Here's a whole bunch of other reasons he died. Who cares? You did an intentional thing to take away someone's life. Sucks to be you. You take the victim as you find him. This is basic principles of law. It is not controversial. This is black letter stuff, guys. Yeah. To qualify as superseding cause, however, the independent action must actually intervene to break the causal chain, must occur after the events, and must be the sole cause. Chauvin's speculative actions are therefore legally insufficient to break the causal chain. 100% right, yeah. Chauvin's arguments are also founded on the shoals. Oh, also founder on the shoals. Okay. Chauvin's arguments also founder on the shoals. I didn't really like this turn of phrase, but whatever. That's a stylistic critique. On the law that obligates the court to view the evidence in light of the state, at this point, yes, and draw all reasonable inferences from the state. At this point, yes. This is 100% correct. This is not controversial. Notwithstanding Chauvin's contention that Floyd was suffering from a fentanyl overdose, Floyd did not, during his interactions with defendant, display some of the common signs of fentanyl, such as falling asleep, snoring, or nodding off. Although excitable and partially non-compliant in the earliest moments of his interactions with Lane, after he was startled by Lane's tapping on the window, by the time Kung walked Floyd over to Dragon Walk Restaurant, Hampstead on the Sidewalk, Floyd was at least responsive, compliant, and conversive during the approximate 2-minute conversation, answering questions and having Kung calm down. Fair enough. Nor did the fentanyl levels in his blood after death revealed by the autopsy necessarily demonstrate an overdose. Not that it would necessarily matter, as I've been taking some pains to explain. In response to the motion to dismiss, the state counters the fentanyl levels in the body increased significantly after death, pointing to various studies. Okay, that's sure. I'm fine. Here, Floyd's physical state in the minutes before he was pinned down, not to mention his physical state in the first minutes after he was restrained, with the knee firmly placed in his face in the concrete, and with Kung and Lane kneeling on his back and legs, respectively, during which time he continuously told defense he could not breathe and exclaimed, exclaimed that Chauvin's Neo's neck was killing him, viewed in the light most favorable state, and with all reasonable inferences in favor of the state, which is what we normally do at this stage of the proceedings in a criminal trial. Calm down. Presumption of innocence is alive and well, people. This is perfectly normal. It was suggested Chauvin's Austin caused Floyd to stop speaking, moving, and breathing, not an overdose. At least in part. And that's all you really need. Moreover, the examiner's autopsy report disclosed the toxicology reports revealed several drug and psychoactive substances in the system. The autopsy report classifies the manner of death as a homicide. Yeah, it wasn't an accident, it wasn't suicide, it wasn't natural causes, it wasn't like whatever the drugs are. No, it wasn't an accidental overdose. It also lists the cause of death as cardiopulmonary arrest, a heart attack, complicating law enforcement subdual restraint and neck compression from the knee on the neck. He had a heart attack from his knee on his neck. Big words there, right? Non-drug overdose. The statement Chauvin cites from Andrew Baker, the Hennepin County medical examiner, does not rise to the level of legal exoneration, establishing incontrovertibly, which is exactly where we need to be, that Floyd's death was caused by the drug overdose rather than Chauvin's conduct. Right? No. Yeah, no. Dr. Baker had commented that Floyd was found at dead home alone, or if there are no other apparent cause of death other than the levels revealed in toxicology test, it could be acceptable to cause his death as a drug overdose. Right. You know, if there were no other things that were going on, right, then a medical examiner probably would conclude this is a drug overdose. Right. But there were other things that were happening. Right. That radically changed that conclusion. Correct. Deep thoughts. Dr. Baker expressly clarified, however, he was not saying fentanyl overdose killed Floyd. Right. And also, even if it did, that doesn't necessarily answer the question, because the question isn't, as I've been taking some pains to point out, the question isn't, did the fentanyl kill Floyd? That's not the question. The question is, did the cops kill Floyd? They can both have killed Floyd. They can both be but-for causes. But if the cops are a but-for cause, they are hosed. It's not even the right legal question. The final autopsy report, as actual conclusion, the cause of death was the heart attack, on the basis of which they ruled the death a homicide. Simply stated, Dr. Baker concluded that Floyd's death was not caused by the overdose, but rather complications arising in the manner from which the subdue occurred. Yeah, that's law. That's easy. This is easy. This is easy law land, man. This is easy law land. I mean, this is like, shooting fish in a barrel or whatever the analogy is at this point, This is so uncontroversial and so black letter and so easy that the defense lawyer has to throw everything against the wall, right? The defense lawyer has to throw everything against the wall because their client's life and their future is on the line. So in particular in this situation, I don't blame the defense lawyer for trying. I don't blame the defense lawyer. If I were the defense lawyer, hell, I'd be trying anything. It's my job to try anything. I don't blame the defense lawyer. But as an objective judge, I mean, this is so easy. It's like, I don't even have to try. This isn't like one of these really complicated questions of maybe it's this, or maybe it's this, or maybe it's this, or, it's like, this is like black letter, straight line, easy, by the numbers. I can do this in my head without breaking a sweat. No problem. We haven't gotten to the most interesting issue for me. The most interesting issue for me, as I mentioned much earlier in this stream, is whether or not we can use the underlying assault as the underlying felony. Because as I mentioned, that wouldn't fly in a lot of states. So that is the issue I'm interested in. But so far, the judge is saying, you know what? 1 + 1 is 2. And 2 times 2 is 4. And A comes before B. And most of the time, the sky is blue. These are the kind of things the judge are saying. And I'm like, yep, I learned this in the equivalent of kindergarten in law school world. This is just basic, easy, no problem. Watching You Daily says he was in an excited delirium state. The combination of other drugs. When someone is in an excited delirium state, physical restraint is required. That's true. That could be potentially true, Watching You Daily. And as I mentioned earlier in the stream, and I don't know if you were listening or not, so I'm happy to repeat it. But as I was mentioning, to say what the police did would be appropriate in some circumstances is not to say it would be appropriate in all circumstances, right? And the manual and the police manual and police training speaks to this. and speaks to the various things that you're supposed to be doing, like and various processes you should be doing. So you say, well, physical restraint was required. Okay, accepting that as a premise, that physical restraint was required, that doesn't mean that at some point it became unrequired. That doesn't mean that at some point it became criminal, right? So any act can be both criminal and non-criminal. You know, you don't know whether an act is criminal or non-criminal. It depends on like the situation, right? You can't simply say that person X did person Y, the thing to Y, and it's criminal. You know, the act, it depends. And so like the act may have been non-criminal at the start and have become criminal somewhere along the line. So even assuming restraint was appropriate, at some point, there might have been a point when it became so inappropriate and so unwarranted to become criminal. So, you know, to say that like the police were right in their initial actions doesn't really answer the ultimate questions. And that would be true, in a a non-police context. I'm hard to think of a scenario of where that would necessarily occur, but you could concoct a scenario where a person could do a series of things that would be non-criminal. At some point they become criminal. There's some point in there that, you cross a line. Yeah. But, fair question, and I hope that addresses that at least a little bit. When Chauvin remains free at trial to contest the medical evidence and cause of death, of course, as well as cross-examine on the conduct of the autopsy, of course, his conclusions and discussions with others, including lawyers from the office he met with during the week after the door, those remain matters to be presented at a jury. Right. This is ultimately questions of fact for a jury, and they don't provide a basis on which you can dismiss at this stage. Correct. He may ultimately be able to win at trial. We're not there yet. It must again be stressed that at this stage, the court must view all the evidence in light of the state, not the light most favorable to the defendant. That's correct, because of where we are. As to Chauvin's assertion in his brief that Floyd ingested fentanyl in his car at the time they first approached, that is at best a subject for argument at trial. Yes, but provides no basis to dismiss this charge for lack of probable cause. Right. Whether or not he did take the fentanyl in the car is really not the operative issue, because the issue is the fentanyl the sole cause of death? So he took fentanyl in the car? Sure. Okay. It doesn't really tell me what I need to know in this legal analysis. The only evidence Chauvin cites in support of the assertion is a single still flame of photograph extracted from the video. But from the start of the interaction with the officers 15 seconds earlier, before the time depicted in the still frame, although obviously startled to see Lane, Floyd had been speaking normally, giving no indication he had any drugs in his mouth. They're basing this on one single frame of video, man. That's, it's clutching a little bit at straws, but when you're the defense man, got to clutch at straws sometimes. So I don't blame the defense for trying, but at this point, no. Chauvin also argues that Floyd was susceptible to the heart attack based on several pre-existing medical conditions. I've gone to some pains to point out why that doesn't matter. I don't feel like repeating myself. Hereafter, Floyd's condition does not matter for the causation. The physical condition of the person who died at the time the act was done will not excuse or minimize his conduct. If a causal connection between it and the fact of death is made to appear. Yeah. At the time Minnesota's court held in this case, is immaterial to the defendant did not know the deceased was suffering from a condition which facilitated the killing and did not know. Yeah, it doesn't matter the defendant didn't know the deceased was suffering from this condition. Right. Correct. It doesn't matter what the person who was doing the bad thing knew with respect to the condition. Correct. And it doesn't matter that he did not reasonably anticipate his act would cause death. Correct. This is basic. This is trivial. Eggshell skull doctrine. You take the victim as you find him. It doesn't matter that you didn't know. It doesn't matter that you didn't anticipate that. Sucks to be you. Yeah. Responsibility attaches for an injury which causes or contributes to the death, although the condition from which the victim was suffering might itself have caused death in time. I mean, yeah. I mean, I've been saying this for a little bit now. Here's a case from Minnesota Supreme Court that says exactly what I've been saying. This is basic. This is trivial. In short, his pre-existing medical condition cannot defeat causation. No shit. Yeah, we were all well aware of that. Yes. Un- Ultimately, as the state rightly observes, the theories of causality do not exonerate him. Right. Even if Chauvin were correct that these other causes contributed to the death, the law doesn't care. The fact that other causes contributed to death does not relieve the actor of his responsibility. Ding, 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 ding. Yes. So long as actions hastened, yeah. So long as his actions hastened or accelerated the death by like 1 second and contributed to its cause in 1%, it doesn't matter if other causes corroborated to the death. Correct. Black letter. Easy. Sucks to be you. Don't commit crimes. Chauvin's actions here meet the standard for reasons articulated earlier. To the extent Chauvin disagrees, his arguments present a fact question for the jury. Good luck with that, but not a basis for granting the motion to dismiss for lack of probable cause. Right. Yeah, Joseph said, so if I understand this, when a person jumps off a 200-foot high bridge to commit suicide, if he's shot before he's landed, he's murdered. Yes, correct, 100%. If you can establish for an absolute fact that the 200-foot fall from the, 200-foot fall or 200-foot jump from the bridge would have definitely killed him because maybe it was a 200-foot jump from a bridge onto concrete. Yeah, so if you can establish for an absolute fact that the 200-foot jump would have killed this suicidal guy, if some sniper shoots him through the heart on the way down, then the sniper is guilty of murder, even though he would have died like a tenth of a second later. Oh well, probably shouldn't have shot him through the heart. Sucks to be you. Yep. As for his intent, Chauvin alleges the evidence shows that Chauvin demonstrated a concern for Mr. Floyd's well-being. Yeah. There's actually a story around these lines. There's actually a story around these lines, and I don't know if it's apocryphal or not. But it's a story I once heard that demonstrates the point. It's a well-known story. You can check Snopes. I'm sure they have it on Snopes because it's a fairly well-known story. But there's this well-known story along exactly these lines. So, the apocryphal tale is a guy jumps from the top of like a 10-story building onto concrete below, and the police are investigating. So initially they say, well, it's suicide because he jumped from the top of a 10-story building and you know, it would kill him. But as it turns out, the police then discover that what happened was he was actually shot on the way down, because what happened was there was a person there in an apartment. There was a person who was threatening their wife with a gun, right? And so this person threatening their wife with a gun, and the person shot the gun, and it missed their wife, went through the window, and struck the guy on his way down. That makes it murder, right? Because now it's the shot that killed him. And then the twist in the story is that what actually happened, as the police further investigated, that it turned out that this thing with the husband threatening his wife with a gun was something the husband did a lot and was well known. It was part of their like marital dispute. He did it all the time, and he always kept the gun unloaded, right? So he didn't know it was loaded. So he didn't have the intent to kill. So then it becomes a question of who loaded the gun, right? Because now because this person who loaded the gun may be responsible for the murder. And then as the story goes, there was a lover of this guy's wife who knew that the husband did this thing. And so he was trying to get the husband to kill the wife because of jealousy or whatever, you know, that the wife wouldn't leave. And, you know, so he was trying to kill her because he wouldn't leave with her, blah, blah, blah. So, you know, the lover of this woman was trying to get the husband to kill the wife because the wife wouldn't leave him or whatever, bizarre hypothetical. So now we have to like find out who the lover of the husband is. And it turns out that this lover was becoming increasingly depressed because his attempts to get the woman to leave with him were completely unfruitful. And, you know, he'd been trying for a long time to get the woman to leave to with him, and she wouldn't do it. And, you know, he happened to know that the husband would do this ritual. So he loaded the gun. And, you know, they went a long enough period without this ritual being displayed that he became so depressed that he jumped from the top of a 10-story building. And so then it becomes a suicide. Again. So yeah, that's the apocryphal tale, but that's the story. So there, hopefully that's helpful. And there are versions of that story which add in like nets and other things to make it more complicated, but you get the idea at least. Anyways, as for the intent, Chauvin indicates the evidence shows that he had a Chauvin indicates that Chauvin demonstrated concern for well-being. Okay, the state contends the evidence tells another story. Viewed in the light most favorable to the state, the court must agree. For example, the state notes that Chauvin on a couple of occasions responded to Floyd's exclamations. He couldn't breathe by telling Floyd, "You've done a lot of talking, a lot of yelling. It makes a heck of a lot of oxygen to say those things." Chauvin continued to press his knee into Floyd's neck even after Floyd repeatedly cried out that he could not breathe and Chauvin was killing him. And even after bystanders told Chauvin that Floyd was not responsive and he was not breathing. Chauvin maintained his position for several minutes after Floyd had stopped talking, moving, and breathing, and even after Lane acknowledged that Floyd had passed out and twice asked if they should roll Floyd onto his side. Chauvin did not move when Coyne told him twice in the space of less than half a minute that Floyd no longer had a pulse, or even where EMS arrived on the scene to attempt to check for the pulse. Viewing the light most favorable to the state, those are not the actions of someone concerned for the Floyd being. Chauvin also asserts that he could not have intended to cause harm to Floyd because the decision to use the tactics he used complied with policy. So this is what a lot of people have been saying. What he did was within the procedures. Okay. He said, well, my decision to use this complied with policy. But then the court knows Chauvin and others did not actually use the policy, which involves using two hobbles connected in front of a subject. I have no idea what a hobble is, but whatever. The defendant did not hobble Floyd at all. This is capital H, hobble, which is a proper noun, so I don't know what that means. Had they used hobble available to him. What is a hobble? Theo had retrieved it from the rear of Lane and Kung's squad, just as Chauvin, Kung, and Lane had decided to try to stop Floyd in the back of a car and take him to the street. Defendants could have restrained Floyd without kneeling on top of him and restricting breathing. The MRT also calls for the use of a side recovery position as soon as possible. In contrast, the defendant continued to restrain him face down in an inherently dangerous position, with Chauvin kneeling on the neck long after any justification for the use of the procedure had evaporated. Finally, under the policy, whenever the MRT is used, a supervisor must be called to complete a force review. The defendant did not do that. In fact, taking the evidence in the light most favorable to the state, the juror, as trial of fact, could ultimately conclude the defendant decided not to use MRT in the first place because of the administrative reporting requirement, not, as Chauvin now claims, because they could get Floyd in the ambulance more quickly without a hobble. Hobble is a piece of rope. Hobble is binding legs. Yeah, but it's capital H, which suggests it's a proper noun, which suggests it's like a physical object. I know what like the verb hobble means, but it's a capital H hobble, which suggests it's a proper noun. It suggests it's the name of a particular object. So, yeah, what is a hobble? It has a proper name because it's capital letters. Okay. Apparently, a capital H hobble is a proper noun. It refers to a specific thing, which no one seems to know exactly what that is. Hobble is a brand of something. It must be a brand of something. Yeah. Okay, anyways. Finally, Chauvin says he could not have intended to inflict harm because there's no bruising on his back or evidence of blunt force trauma. The answer the state need only establish at trial that either Chauvin intended to perform a physical act that results in bodily harm or intended to cause harm to have him at fear. In other words, at trial, the state can prove that blows to the victim were not accidental but were intentional. Fair enough. Because there's no dispute that Chauvin's actions were not accidental, which, be kind of hard, in pressing his knee into his neck for more than 9 minutes and 40 seconds, that's a hell of an accident. Yeah. Oh, so a hobble restraint device is like a hog tie. It's a specific branded hog tie, like a handcuff. Fine. Okay, great. All right, fair enough. Intentionally performed a physical act that's entirely irrelevant to this action, but in any event, the autopsy report does report a number of blunt force injuries to the forehead, face, upper lip, and shoulders, hands, elbows, and legs, due to the manner in which Chauvin, Coyne, and Legg had subdued them and pinned them to rest. In sum, Chauvin's arguments misapprehend the law and are predicated on viewing the facts in the light most favorable to the defendant, which is not how we do this at this point. They provide no basis for dismissing the underlying second-degree murder charge. Okay. And then they're not going to get into any of the issues dealing with the underlying issue with the underlying assault being a predicate felony. That's annoying. Yeah, that's a little bit annoying. There's no analysis from the trial court here at all on what I think is the most interesting legal issue, which is using the underlying assault as the predicate felony to the murder. which doesn't seem like the kind of thing that would fly in a lot of places. Now, maybe it flies in Minnesota. But yeah, I don't think it would fly in a lot of places to use the underlying criminal assault as the underlying felony for the murder. That wouldn't normally fly. And maybe that's correct under Minnesota law. I mean, it wasn't carved out in the statute, right? The statute said any felony other than particular kinds of sexual assault or drive-by shootings for some reason. But it didn't say like underlying assaults. But that being the case, however, even though it's not in the statute, it's a pretty well-known principle in like common law. And Minnesota could presumably have overruled that in its statutory law. But there's no analysis at all. There's no citation to any case from a court of appeals or a Supreme Court in Minnesota that says that you can use this or analyzes it in any way. That's annoying for me as a legal commentator, because I think that's the most interesting legal issue. Like up till now, the court has been telling me grass is green as far as I'm concerned. Right? I'm like, yes, I know all these things. Please tell me something I don't know about using the underlying assault as the predicate felony to the felony murder, because that doesn't sound like a thing you can do. And if it is a thing you can do, I'd like to learn something. Please teach me. Please teach me, court, so that I can learn something. And the court doesn't want to teach me. I'm sad. I am frustrated as a legal commentator. I've been denied learning something. That's annoying. Yeah. Okay. Well, we press on, I guess. Let's go to the third-degree murder. That's annoying. All right. Let's discuss the third-degree murder now, which has been dismissed. Yeah. Oh, well. Yeah. This is super frustrating. Up till now, the court has been telling me grass is green. I was like, I know all this. This is easy. I could do this off the top of my head. You cited cases, not like I needed citations to cases. I know all this. I know that this exists. So you don't have to tell me a case that exists for this. You're telling me bombshell propositions like at this stage we should look at it the light in the most favorable to the state. And at this point, you take the victim as you find them. And the jury could find that it was intentional. And all your arguments to the contrary are at best factual arguments for a jury. Why are you talking to me about it? Grass is green. And the court completely ignores the really interesting legal issue. That sucks. All right, let's press on. Under Minnesota law, a person is guilty of third-degree murder if, without intent to affect the death of any person, without intent to affect the death of any person, the defendant causes the death of another by perpetrating an act eminently dangerous to others and evincing a depraved mind without regard to human life. To prove that Chauvin is guilty of third-degree murder, the state must prove the following elements at trial. What do you mean the underlying whatever? Murder requires a felony. Felony murder does require an underlying felony, yes. But what is the underlying felony? The assault. And it doesn't quite make 100% sense. But yeah. So it's a little weird. I went to some effort to explain it. I don't know what to tell you. To prove that Chauvin is guilty of third-degree murder, the state must prove the following: that Floyd died, that Chauvin caused the death, and Chauvin's intentional conduct that caused Floyd's death was eminently dangerous to other persons, and this is where it's going to fall apart. You can tell where it's going to fall apart right away. Eminently dangerous to other persons, and was performed without regard to human life. Such an act may not have been specifically intended to cause death, and may not have been specifically directed at a particular person whose death occurred, but it must have been committed in a reckless or wanton manner with knowledge that someone may be killed, and with heedless disregard to it happening. The focus here, for the purposes of probable cause, is the third element. To find probable cause to allow the state to proceed, the state must point to evidence not only that Chauvin's intentional acts were eminently dangerous to other persons, which, yeah, but also such actions may not have been specifically directed at a particular person to whose death occurred. That's going to be a problem. The issue here, given the statutory language, the manner in which Minnesota appellate courts have construed the language, and Minnesota's third-degree jurisprudence is not so much whether Chauvin conducted towards Floyd during the critical 9 minutes and 20 seconds was eminently dangerous, or poured forward without regard to human life, or done in a reckless or wanton manner with knowledge that someone may be killed with heedless disregard, Those are also elements in viewing the lights most favorable to the state and drawing all reasonable inferences. The state might well be entitled to proceed on this trial if that was all that was required, but not so much. The language of third-degree murder statute explicitly requires the act causing a death of another must be eminently dangerous to others. And that's where it's going to fall apart. In defining the crime, the legislature could, of course, continued in the singular, or could have concluded both an actual victim as well as others. An example of the first approach would have been the following, and now we're going to rewrite the statute to show another possibility. An example of the latter approach would be, here's another example of how you could have drafted this. The legislature did not take these approaches, though, but instead required the defense actions were eminently dangerous to others. And this court must give effect to the plain meaning of the statute. Chauvin argues, relying on prior law, that Minnesota law does not permit a conviction for third-degree murder where the defendant's actions were focused on a specific person. According to Chauvin, because his actions were directed to no one but Mr. Floyd and could not have resulted in harm to any person other than Floyd, probable cause does not exist for a third-degree murder charge. And this court agrees, which sounds perfectly plausible. The prior case of State versus Zernberg is instructive. Zernberg arose from a fraught, deteriorating relationship between defendant and victims, his neighbors, over a couple of years. The defendant did not like deer in the neighborhood, whereas the victims enjoyed feeding deer in their backyard. A dispute over deer. That's good time. I don't like deer. You're feeding deer. Oh, man. A couple of years before the shooting incident, the defendant had written neighbors expressing frustration about the deer. Not long after, the victim found mutilated animals in their yard. Nice. This is a neighbor dispute gone wild. Mutilated animals in the yard and suspected the defendant was responsible. When the girlfriend confronted the defendant about the animals, the defendant allegedly threatened to kill her, leading to her obtaining a restraining order. As tensions between them continued to rise, the girlfriend accused the defendant of blowing an air horn to scare the deer when he saw them feeding in the yard. Nice. Another neighbor recounted at trial a conversation which the defendant said it would all soon be over. The girlfriend later called the police to report the defendant's son had threatened to kill her, and the police told her to call them if she saw him again and they'd arrest him. After the incident, the defendant kept a loaded shotgun under his living room sofa. You see exactly where this is going, right? On the day in question, the police had arrested the defendant's son when they saw him at a local bar. Defendant and his wife learned of their son's arrest. When the girlfriend returned home, defendant's wife provoked a confrontation, standing at the end of their driveway, yelling at the girlfriend, who was standing outside the front door of the victim's house across the street from the defendant. Nice. Whose girlfriend is this? Is this the husband's girlfriend? Oh, no, it's the other girlfriend. They should have changed the vernacular. As the shouting match continued, the other victim came to the house to stand alongside his girlfriend. Seeing this, the defendant, who had been watching the confrontation between his wife and the girlfriend victim, retrieved the loaded shotgun, went into his basement, climbed out an egress window, and fired 4 shots, 3 of which struck the male victim and a 4th which struck the girlfriend as she tried to run back home. The male victim died. The girlfriend was hospitalized but recovered. The defendant was convicted at trial on counts of first-degree murder, and attempted first-degree murder and second-degree murder, and attempted second-degree murder. The defendant had requested instruction on third-degree murder as a lesser-included defense, with the trial court denied. The defendant testified at trial that he fired a shotgun to scare off the victims, but he had not intended to hit either of them with the shots. Oh, well. The Minnesota, maybe not aiming directly at them then would be a good strategy if that's what you're trying to do. The Minnesota Supreme Court held a trial court had not erred in refusing to instruct the jury on third-degree murder as a lesser-included offense. The court held that third-degree murder cannot occur where defendants' actions were focused on specific people. As Chauvin notes, the Minnesota Supreme Court has explained, for a jury to be instructed on third-degree murder, the act must be committed without special design upon a particular person or persons to whom the murderer is accused. Although the defendant had testified he did not intend to harm them, the court concluded in light of his testimony he had fired a gun intending to stop the male victim. The shooting was done with specific regard to a specific person, and such targeting purpose to demonstrate a specific design that precluded conviction on third-degree murder. The same principle was determinative in a different case. In Stiles, the defendant and several friends arranged to meet a victim from whom they previously met brought drugs in a park under the pretext of buying drugs, but actually intended to rob them of the drugs. People are trying to steal drugs from someone they arranged to buy them from, man. Shouldn't do that. When the victim presented the drugs, the defendant companion who came over the car, the defendant and another of his companions jumped out of their van, pointed shotguns at the victim, and demanded he give them the drugs. Rather than complying, the victim tossed the drugs back in the car and reached towards his waist where he had a gun stash. Drug dealer is not particularly interested in this. Defendant and one of his accomplices, who were within a few feet, fired shotguns at the victim, striking him several times, and the victim died. Defendant was tried and convicted on counts of first-degree felony murder and intentional second-degree murder. Yeah. My purpose in shooting was to effectuate a robbery. Someone died. Yeah, that'll do it. In rejecting defendant's argument, the trial court had erred in refusing to instruct on the lesser included charge of third-degree murder. The Supreme Court reasoned that the third-degree murder statute excludes a situation where the animus of the defendant is directed to one person only. In styles where the defendant intended the victim and evidence would not have supported a finding, defendant's actions were eminently dangerous to more than one person, which the court construed third-degree murder statutes requiring. Because there's no evidence the defendant has shot anyone or anything other than the victim, and no circumstantial evidence the defendant's action had endangered anyone other than the victim, the court concluded the trial court properly declined to instruct the jury on third-degree murder, which the court noted is generally used when no specific individual is. To the same effect is Barnes. Not that Barnes. Different guy. Not that Barnes, man. In which the Supreme Court holding a third-degree murder cannot occur in which defendant's actions were focused on a specific person, reasoning that the statute was intended to cover cases where defendant's reckless or wanton acts were committed without specific regard to any particular person. The act must be committed without special design upon any particular person to whom the murder is charged. Yeah. And then we get a whole bunch of citations, which we'll skip for today's purposes. Citations, more citations, lots of citations. This has come up a couple times. So the court just cited like 8 different cases that basically stand for the same proposition, so we'll skip all that. In contrast to these cases is the case of State versus Waltz. It provides an archetypal example of the situation third-degree murder statute is intended to cover. Defendant there, while driving around with a woman companion, had stopped at an acquaintance's, leaving his companion in a car when he went for drinks. That's mean. He's driving around with a woman companion and stops at a friend's house, and he goes in for drinks and leaves his woman in the car? Yeah, that's not really nice. Jeez. Emerging half an hour to 45 minutes later, stumbling with glassy eye, apparently intoxicated, and carrying a couple of glasses of undetermined liquid, which, we could probably take a guess. Upon returning to his car, he found his waiting woman companion in a fit of pique. You don't say. Why would his companion woman be piqued at this situation? Why would the woman be a little bit irritated at being left in the car for half an hour, 45 minutes while he went into the friend's house to have drinks and then came out drunk? Why would the woman potentially be irritated at this? Hard to say, right? Jeez Lord. After she poured out the contents of the 2 glasses, an argument between them ensued, I would think, after which she exited the car, refusing to ride with the defendant. Yeah. The defendant, then in a highly excitable state and seething with anger after the argument, drove off in his car, speeding down the streets of St. Paul at what some witnesses have estimated had been 50 miles an hour. A woman in a group happened to be crossing the street as defendant came barreling down the street. Defendant's car struck the woman, knocking her down, upon which the car ran her over, producing injuries from which she died the next day. Defendant was still not done, however. Having just committed a hit and run, that's great. He continued on, driving recklessly and scattering pedestrians who gathered at the site where he had knocked down and driven over one who had been crossing the street. As police on a motorcycle began pursuing him and shooting at the tires in an attempt to bring him to stop. Rather than stopping, he began swerving his car from side to side in the street to attempt to run over the officers' motorcycles or force them over the street. The Supreme Court affirmed his conviction for third-degree murder. After surveying the historical development of murder and manslaughter, the court described the nature of the cases contemplated for third-degree murder. So here's what the court thinks third-degree murder is meant to encompass. Cases of depraved and reckless conduct aimed at no one in particular, but endangering indiscriminately the lives of many and resulting in the death of one or more. Acts perpetrated with full consciousness they're calculated to put lives of others in jeopardy, and cases which were reckless, mischievous, or wanton, which were committed without special regard to the effect on a particular person, but reckless disregard of whether they injured one person or another. So we didn't really care who we were trying to hurt. Indeed, reckless driving of a vehicle resulting in the death of another is a general fact pattern in which most of the cases affirming third-degree murder convictions arise. For example, in another case, the defendant, while intoxicated, was driving a snowmobile at 58 miles an hour. Wow. Snowmobile at 60, man. Yeah. At night on a lake with numerous fishing houses, snowmobiles, and other vehicles, and many people on the lake fishing. The defendant's snowmobile struck the pickup truck of another family out fishing that night and ran into an 8-year-old boy before careening into an ice house where his boy's father was. Defendant was thrown from his snowmobile. The father was injured and the boy died. Horrible. That's horrible. The Court of Appeals affirmed the third-degree murder conviction, concluding defendant's conduct under these circumstances created a substantial and unjustifiable risk to human life and conscious disregard of that risk as required by third-degree murder, although not, of course, had been specifically focused on anyone in particular. 58 on a snowmobile, man. That's special. State versus some other guy. Another drunk driving case resulting in fatality is representative. In that case, the intoxicated defendant engaged in numerous reckless driving behaviors while driving. He was talking on his cell phone while driving. At times, he swerved in and out of traffic, switching back and forth between lanes. He had driven the wrong way down a one-way street, had driven speeds of up to 115. Finally, he was driving about 60 on a street with a 30 limit when he rounded a curve and lost control of his car, you don't say, upon which his car skidded sideways into an oncoming lane and onto oncoming traffic. In the lane, struck on the passenger side of the defendant's vehicle, knocking it off the road. All 3 passengers in the vehicle were rendered unconscious by the crash. One of the passengers died, another suffered a broken leg, and the third received cuts and bruises. 4 occupants in the oncoming vehicle that crashed into defendant's vehicle were also injured. Defendant did not lose consciousness. After getting out of the vehicle to pee, he got back into the car. So after causing this massive accident, he decided to get out of the car not to help, but merely to pee, and then got back in the car, drove back up to the curb to get back on the road, nearly striking other bystanders, and drove away from the accident. After running a red light and down the street at almost 80, defendant stopped in a church parking lot, dragged the unconscious bodies of all 3 passengers from his car. Wow. Leaving them on the pavement. And this incident occurred in the dead of winter. Wow. That's special. So after getting into an accident and knocking all of his passengers out, he drove to a nearby church and dragged the bodies out and left them on the cold ground in January in Minnesota. Super. He was later stopped by a state trooper who noticed him weaving on the road in his damaged vehicle. Testing revealed his blood alcohol time about 3 hours later to be 0.15. Finally, yeah, that's not good. So finally, after this other case, the defendant once again had been drinking. While intoxicated, then he drove recklessly, driving more than 60 miles an hour on residential streets, nearly colliding head-on with a car, forcing 2 pedestrians off the road before turning around and chasing them off for the second time. Fleeing people had begun pursuing him, during which he drove at speeds of up to 80 on residential streets, seeking to evade the police, running through a roadblock, running several stop signs before eventually striking and killing a driver. Yeah, this is yeah. The court's research has not disclosed any published Supreme Court or Court of Appeals opinion affirming third-degree murder in a case presenting analogous patterns to that which we have here, in which the defendant allegedly criminal conduct was directed at and specifically focused on a single victim and where the defendant's conduct did not present a risk of harm to others. The state also points to a statement in State v. Wahlberg as standing for the proposition conviction on third-degree murder could be sustained where defendant's shots were aimed at the decedent alone. However, as indicated above, although that opinion disclosed the defendant there may have intentionally fired at the former lover, he was not the decedent. Rather, the decedent, the victim for the purposes of the third-degree murder statute, was the lover's former wife, who was also in the apartment, as struck by 2 other bullets the defendant had fired while in that apartment. While incidentally, one would think that would qualify for second-degree murder because intent follows the bullet and all the rest of that. But apparently, for whatever reason, the state charged for third-degree murder, even though you would think second or even first-degree murder might be possible. Because you had tried, with intent, to fire at someone and then struck someone else. So, normally that's not a problem. But for some reason, the state went with third-degree murder for some reason. Okay. Nothing in that review of the underlying facts demonstrates the defendant had purposely sought out the wife after shooting his former lover and intentionally fired the 2 bullets that wound up specifically killing her. No, okay. In any event, the Supreme Court held the trial court had not erred in refusing to instruct the jury on third degree as lesser included first degree because they showed that all the blows were directed toward the victim. Okay. No, I misunderstood the predicate. I was understanding they did charge third degree murder. I was like, that doesn't really make sense. And then that, like, yeah, the Supreme Court said, no, you were right the first time, Blackleaf. It doesn't make sense. It is first degree murder, not third. Yeah, because all the blows were directed to the victim and the intent transfers. Okay, my faith in my understanding of criminal law is restored because like that seems weird. Why was this third degree? And then they're like, no, it's actually a first degree. I'm like, ah. And so then there's another case which deals with this stuff. Okay, blah 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 blah. Because third-degree murder can be sustained only in situations where the defendant's actions were eminently dangerous to other persons and were not specifically directed at the particular person whose death occurred, this is not an appropriate case for third degree. The evidence presented by the state does not indicate that Chauvin's actions were eminently dangerous to anyone other than Floyd. More importantly, Chauvin's actions were, of course, specifically directed at particular persons whose death occurred: George Floyd, upon whose Chauvin kneeled for more than 9 minutes, pressing Floyd's upper chest area, neck, and throat, and face into the concrete. So that brings us to the end of our discussion of this case, for the moment at least. Because there's a lot of other stuff dealing with the other officers, but we can deal with that in our time if we have to. But our interest, at least for the moment, is in the principal officer involved, Chauvin. And so, yeah, that makes sense. Because it was targeted at Floyd, it can't be third-degree murder. That makes total sense. And then as the second-degree murder, the court completely fails to analyze the legal issue that I think is the most interesting, which is whether or not you can use the underlying assault as the predicate felony in a felony murder. Because normally I wouldn't think that flies. You can't normally do that. Yeah, you can't use the underlying death as the predicate felony in a felony murder. And so they're trying to use the underlying felony assault, which ultimately merged. So that, yeah, ultimately merged into the murder. And I wouldn't think that you could do that, as merger doctrine and stuff like that. So the court completely ignores what I think is the most interesting legal issue. And that isn't to say that in Minnesota that you can't do this. I don't know Minnesota law that well on this issue. I have no idea. I just know as a general matter, this is a little weird. Because under merger doctrine, you would think that the assault would merge into the murder, and then you can't use the murder as the underlying felony for the murder. But they're essentially trying to use the underlying murder as the felony for the murder, and you can't do that. But here they say you can, which may be legally correct in Minnesota, but the court does no legal analysis of any kind on that legal issue, which I find really annoying because I wanted to learn something. And I've been deprived of my opportunity to learn. And that is irritating to me. The court was going to teach me something. It was going to teach me something about Minnesota law. It was going to teach me something about how Minnesota views merger doctrine. It was going to teach me all kinds of things. I was going to learn something. Oh, well. I learned nothing. I learned that grass is green. And I learned that in the third-degree murder statute, you have to target others. Okay. Yeah. All right. Great. I was kind of already there. They taught me nothing. That's annoying. Oh, well. You can't always have what you want. Why don't I want to go over second-degree manslaughter? Just in the issues of time. Because I think those are the most interesting issues. And we've been doing this for an hour. And we can cover it another day, perhaps. But, I don't want this to just become a completely extensive thing. The murder statute is the murder charge is obviously the more interesting charge than the manslaughter. Maybe we'll cover it another day. Minnesota doesn't use the independent felony rule. Maybe they don't, but that's like, I wanted the court to teach me and they didn't teach me. You say that, well, Minnesota doesn't use it. It's like, the court didn't teach me. And then someone says, well, look at this case, State versus Branson. I'm like, yeah, maybe I would look at that case, but even if I can go find out the answer by Westlaw or by looking it up, even if I can't find out the answer, I'm still irritated at the court. Because the court is the one writing a legal opinion, right? The court is the one doing a legal analysis, and this is an interesting legal issue. And you would think they would spend some verbiage on it. So whether or not I can figure out the answer, is not the operative issue. It's like, whether or not I can be irritated because the court failed to be a good teacher. I'm like, you failed to teach me something, man. That's lame. That's lame. Oh, well. Anyways, we'll have to figure that out for another day, I guess. But that'll bring us to the end of our current stream. If you liked this stream, if you'd be so kind as to give it a like. If you like my content and you give it a subscribe, it would be super appreciated. And if you've not already done so and you'd like to hit the join button, that would be great. For 99 cents, you too can be a recurring supporter of my channel and help the channel grow. And at some point, because we've already had so many things happen today, at some point I'll have to try to figure out if there's anything interesting to say about the Ghislaine Maxwell deposition. So I'll have to figure out if there's anything interesting to say about that. And of course, this morning, the Judiciary Committee voted to advance Amy Coney Barrett's nomination. It's been a busy day in law land. We can only cover so many things at once. I'm a human being, you know. All right, well, that's the end of our stream for now. Until later, my friends, I hope you're well. Cheers and goodbye.